Okay, welcome back. Our next panel is a new one for this conference, a really interesting one and a very timely one. It's cyber attacks on the supply chain, incident response strategies. And we can have just a terrific panel. Let me start with our moderator, Jenny Arlington, who's counsel at Akin Gump. She has long-standing experience in data protection, privacy, and cybersecurity matters. And is a real thought leader on the subjects of privacy and incident response. She's joining us now from North London. Welcome, Jenny.
Thank you, Bruce. Really nice to be here.
Let me next introduce Andrew Beckett, who is a managing director and EMEA leader for Kroll's cyber risk practice. He has enjoyed a lengthy and distinguished career in cyber, including time with Government Communications Headquarters, commonly known as GCHQ, which provides signal intelligence and information assurance to the UK Armed Forces. He is now in Dublin, at least for today. Welcome, Andrew.
Thanks very much, Bruce. Good to be back.
Next, I'd like to introduce Wim Nauwelaerts. He's a partner at Alston & Bird and part of their European privacy and data security team. Wim has over 20 years of experience working with global companies on their data protection, privacy, and cybersecurity needs, including GDPR readiness, data transfer, data security and breach requirements, and compliance training. Wim is in Brussels. Welcome, Wim.
Thank you, Bruce. Pleasure to be here.
Dr. Christian Schröder is with us today, partner at Orrick. He heads Orrick's IP and IT data privacy practice group in Germany in the Dusseldorf office. He advises companies on IP, unfair and deceptive trade practices, e-commerce, IT, and data privacy and data protection, and is known as one of Germany's leading lawyers in the field of data privacy and protection. He joined us today from Frankfurt, Germany. Welcome, Christian.
Welcome, Bruce. Very nice. Pleasure to be here.
Thank you. Jenny, I'm pleased to turn it over to you.
Thank you, Bruce, for the kind introductions all around. I'm very glad to be back at the forum. And hello to you, everyone in the audience today. It's a pleasure to be with you. And hi to my great panelists. So today, cyber attacks on the supply chain. They're certainly not a new development, but they have been significantly on the rise recently. I'm sure most of us were following very closely when the news about the SolarWinds attack broke out at the end of last year. And such attacks are tricky because they exploit the existing relationship of trust. Certainly, my clients are very much focused on that much more nowadays. Andrew, let me start with you, please. Could you give us an overview of what cyber attacks on the supply chain you have seen and some of the more practical insights as to what they target?
Yeah, sure, Jenny, and great to be working with you again on another panel. I'd like to start just by looking at what do we mean by supply chain. A lot of the clients we work with these kind of breaches ignore the fact that they are also part of their client's supply chain. They think of the supply chain as only running down from them, who are their vendors, who are their suppliers. And they ignore the fact that if they have a problem, there are repercussions up the chain for their clients and customers as well. It's very rare that you find an organization that is only at the top and for whom everything is a supplier relationship rather than supplier and vendor. Attacks on the supply chain are not new. We saw them when I was in government service 20 years ago, quite commonly, when the defense organizations, the government departments who were traditionally the target of state-sponsored attacks had hardened their systems to a point whereby they couldn't easily be compromised. And so they went after the supply chain, the defense industrial sector, those who were providing manpower or financial services into government departments as an easier way of gaining access to their ultimate target. And that is still the methodology, that is still the reason for the attacks that we see today. companies can be attacked either because they have something that an attacker wants, or because they provide relatively easy access into the attacker's ultimate target. And so it's not just when you're looking at attacks on the supply chain, companies need to consider, is the attacker after something that I've got for exfiltration, or to use me as a stepping stone, or indeed to use my suppliers as a stepping stone to me? And that should educate the risk assessment that you're making on any relationship with your supply chain, with any particularly digital connectivity that you are agreeing with your supply chain, either up or down. What is the risk to me? What risk do I pose to my ultimate clients? And all of these are things that go into the supply chain. And as I say, we've seen numerous attacks, and SolarWinds has been a classic example that has brought this back to the forefront of people's minds. A single attack on a single target has led to opportunities for data exfiltration, disruption across, well, the world's economy. And that's why we need to start turning our attention more and more to the supply chain.
Great. Thank you, Andrew. That I completely agree with you. And I think to a degree, as cyber attacks have risen, so has awareness of them, of the risks that they entail. And if an organization is in a fortunate position where an attack has not yet happened, what can they do proactively in order to minimize that risk? I have to say that from my perspective, encouragingly, more companies are looking for such proactive steps. Wim, could you please share some of the pragmatic tips you have given to clients in that respect?
Sure, Jenny, and thank you for that question. I think the key message here is really, let the buyer beware, right? It's actually a message that's also reflected in the GDPR. I sometimes see controllers that use data processors down the supply chain forget two essential principles under the GDPR. First of all, you're supposed to use only processors that actually provide sufficient guarantees in terms of technical and organizational measures to protect data and to comply with the GDPR. Now, that means that during the onboarding stage, you are expected to conduct some type of due diligence on your processor's capability to protect personal data before you actually hire that processor. I mean, it sounds like the obvious, but nonetheless, I think it's often forgotten. And this can be done in many different shapes and forms, but at the end of the day, it's really important that you're able to demonstrate, for example, to a supervisory authority that you have done that due diligence. Have you, for example, received a copy of the processor's technical and organizational measures? Does the processor have an incident response plan in place that actually enables breaches to be detected in an early stage? Does the processor staff receive regular training in an effort to avoid human error, often the cause of breaches? All of these things are critical. And the second principle is that the controller remains responsible for what happens to the personal data that's processed by its data process. Even if in reality, it's very hard for a controller to control the processor and how it actually processes the data. That doesn't mean that processors are completely off the hook in the event of a personal data breach. As a matter of fact, in a recent breach case in Sweden, the supervisory authority imposed administrative fines not only on the data controller who was ultimately considered responsible for the breach, but also one of the data processors who had been hired by the controller, but who in the eyes of the supervisory authority did not take appropriate security measures to protect the data, which then ultimately contributed to the breach. And I think that's why it's important to make sure that you include specific obligations in the contract that controllers and processors need to have under the GDPR with a view to minimizing these risks. For example, instead of just saying the processor should assist the controller in case of a breach, right? It's really in the interest of both parties to stipulate upfront exactly what role the processor will be playing, what information should be provided, within what time frame, and also to pass these obligations on to sub-processors, for example, right? I think that's also quite important. And another tool, Jenny, that I think is often underutilized, in my view, is the controller's right to audit the processor, and in a way, and the way in which the processor actually handling the controller's data. Because, as a controller, you want to be aware, right? If a processor has made, let's say, substantial changes to its internal controls and information security ecosystem, or if it has implemented a new IT system for processing your data, but that it involves a sub-processor, let's say, based in India. And exercising this audits right on a regular basis, I think, helps demonstrate the controller's best efforts to only use processors that can protect the data. And it's a right that should ideally be exercised throughout the life cycle of the supply chain. And I guess the good news is, and let me finish with that the GDPR doesn't really impose too many restrictions there. It offers enough flexibility to controllers and processors to let them organize these audits in a way that works best for them and without interfering too much with their business operations.
And if I could just add to that, Jenny, and give Wim a chance to come back. But if you put those clauses in the contract, the right to audit, but then don't exercise them, you might as well have not had them there, and the regulators will say you are failing in your duty.
Yeah, I think it's a fair point, Andrew. I mean, the right to audit is one of the mandatory clauses that you have to put in your contract, right? It's up to the parties to decide how much they want to elaborate on those provisions, right? But you're absolutely right. I mean, it's again something that's too often overlooked by data controllers.
I agree. One of the mandatory, and I guess one of the things that you have a little bit of wiggle room to negotiate. So with my clients, that's usually where the battle begins as to what to allow and what not to allow. But yeah, great. Both, thank you for that. And we've heard, so processors are not off the hook, definitely. Neither are controllers. We all know they have more responsibilities under the GDPR. And Christian, if I can turn to you. So the question with cyber attacks, we know is not if they happen, but rather when they happen. So for your clients who have suffered a cyber attack, could you please tell us the legal and regulatory challenges they faced? What are the do's and don'ts for our audience that they can take away from here?
Sure, happy to. And even though I think it's a given that cyber attacks will occur, many clients, unfortunately, are not very well prepared. And I would really encourage everyone, and I will kind of focus on that, really kind of to really prepare for these attacks, because unfortunately there are so many legal pitfalls one can fall in. And the first I would think generally kind of is actually to know your data, and I will focus on this later on a little bit more. But you need to understand which data is actually impacted, in particular in the supply chain, right? I mean, if you are receiving data as a processor and processing such data, and such data may be impacted, you are subject to different contractual but also legal requirements in relation to the data as if you were a data controller. You need to really understand the function you're having the data in. And secondly, the data itself. I mean, is it personal data? Which jurisdiction is covered? I mean, where is the lead supervisory authority to which you may have to report to? Is it personal data? Is it other data? And if it's other data, we're talking about IP know-how. There may be contractual requirements to report, or you may need to report to, for example, financial regulatory organizations. Many things to really think about. Clients oftentimes do not think about when this occurs. So you need to really understand in which function you have the data. Are you a controller? Is it the data you process on behalf of others? Is it the data you should not just go ahead and notify, but you may actually be required to inform your customers instead? Most often, clients do not know this because data may be unstructured. Many clients still haven't done a data mapping exercise. That makes it extremely difficult to understand the legal implications, and there are many. Under EU law, as you mentioned already, you need to very quickly understand if the data incident needs to be reported. Is it a minor incident with no risk of harm to the individuals? Then you need to document potentially, right? Is it a more serious incident which requires notification to the supervisory authorities or potentially even to the individuals or customers? How do you want to report? How do you want to do so? And how can you do so if there are other considerations? As I mentioned already, there may be an obligation to kind of reach out to the public to to report, to make ad hoc notices. You need to kind of think about your reputation. You need to have a good PR management in place. All these kind of considerations come at a time where companies are not prepared and where you do not have the time to really kind of think it through oftentimes. So you may just lose very valuable time for preparing and for reacting appropriately. We recently, just to give an example, we recently had a client who did not have a good incident response plan in place and who was actually not so well aware of the legal implications and even the legal definition of a security breach. It took us days to make the client understand that under GDPR, this was a security breach. For internal political reasons, this wasn't the outcome that the client liked. So we really lost significant time convincing the client otherwise and working on good communication strategy to inform their clients. As a result, many of their business partners went away because they simply understood that this company was not well prepared to kind of take care. What we also heard is many business partners nowadays very well understand that these attacks can happen. So they don't freak out oftentimes if that happens, right? But what they really don't appreciate it is the business partner is not well aware of it, of its own legal obligations, and then tries to hide, right? So do's and don'ts, and that may come as an obvious, or it may come across as marketing, but it's not. It's not meant to be. Primarily engage in a legal counsel before doing so, because the legal counsel will be critical to immediately also engaging an IT consultant, cyber incident response teams to really help you understand and mitigate the risks of any cyber threat. You need to go oftentimes through legal counsel because of privilege reasons, and even if you're in Europe, you may not think about the implications in the United States, where many of your affiliates are. So you need to really think about this firsthand. And it is not also maybe obvious, but legal consultants, as well as any other IT consultants, they're expensive. So if you are in a crisis situation and then need to reach out to kind of look for good counsel, you will not likely be able to kind of get the right counsel that has time for you at an affordable price and with actually the attention that you need to have enforced. So be prepared in the way that you reach out to legal counsel and forensic firms much more in advance. Make them become acquainted to your system. Think with them through of where your data is and where you can go. That's one part. Identify and convene your internal incident response team, which should include IT, legal, PR, and communications individuals to lead the incident response. Activate any incident response plan if you have any, continuity plans if you have them in place. Consider the need for any specialist third parties. I already mentioned forensic firms, but communication experts are really important. And last but not least, determine whether you have cyber insurance and work with your lawyers to activate your policy. Oftentimes that's again forgotten, and cyber insurance really require very immediate reaction, in particular if you want to, in the end, get the compensation for example, your lawyers and others. Consider taking communications off the company domain. Consider a secure team site or similar if the threat actor could still be in the system, for example. Please don't treat every incident as a crisis. We see this very often, that we get really, very emergent calls and clients are super active. They have assembled all team members, and in the end we found out it is really not a big deal. This could have been avoided if you knew where the data is and if you had then done a proper risk assessment beforehand. So if you see that there is an incident, react very quickly, but react in the right way. Get again your counsel on board. Don't immediately notify regulators or data subjects, as you usually have more time than you think you do get in order to gather the facts and determine your legal obligations. Acting hastily often results in over-notification and increased risk. And think about it, in particular nowadays that there's third professional litigants waiting to get information in the public to kind of prepare class action damage claims. It is really important to kind of know what you want to report and what you need to report and to whom to report it in a certain time. So it's not just great just to go public and to get it off the hook. Actually, kind of you may cause more problems than you currently have. And do not engage directly with the threat actor. without engaging specialists to determine how best to engage and, if relevant, how to best respond to any ransom request. Don't instruct third parties directly, including security forensic specialists, without first engaging legal counsel, as I mentioned already. Do not delete any files or correspondence. This may be really important to preserve all documents and evidence in the case of future litigation or regulatory enforcement. That's what we see quite often. Again, companies, clients, they start, they work, they immediately delete because their IT has told them, look, these are kind of the bad things. But you may really kind of destroy important factors that may help you actually understand the impact of the damage. Many thanks.
Thank you. Thank you, Christian. That's been really thorough. Thank you. And some really good practical tips for our audience there. So if we fast forward a little bit, so you have had a breach, you've notified the regulator, you've also unfortunately had to notify individuals. If I can turn to you, are there some consequences you're seeing as a result? Have individuals become more willing to seek remedies as a result of a cyber breach? We know the class actions in Britain, they are on the rise. Have regulators become more understanding, or on the contrary, quite demanding? What can companies take away from those trends?
Yeah, sure, Jenny. And I think you're right. I mean, I think we're seeing quite some developments recently. And let me start with notifications to affected individuals. I think these days, it's safe to assume at least three things when you decide to inform data subjects of a personal data breach. First of all, when you notify affected individuals, some of them may decide to actually share these notifications with other individuals or with their supervisory authority, and possibly also with the media. So I think it's important to keep that in mind when you're drafting the actual notification letters to individuals, because this may not be just for their eyes only, and it may sound naive, right? But in practice, we're seeing that a lot of companies forget that, and they're putting a lot of information in their letters that probably could have been avoided. We're also seeing in practice that affected individuals who receive the breach notification are increasingly exercising their data subject rights under the GDPR, and not just the right to access, which is obviously the basic right that opens the door to all the other data subject rights, but for example, the right to deletion. And they will immediately say, I'm not happy with the breach and I want all my data to be deleted, for example. And so the question to ask yourself before sending out these notifications to individuals is, are you able to handle a potentially large volume of data subjects requests if they come in, and also within the timeframes of the GDPR? And in practice, that can be a real challenge. And the third assumption is that some of these affected individuals may actually raise a possibility of compensation. And we're seeing that now more and more, or at least refer to their right to compensation under the GDPR, which are two different things. And we're probably not going to see massive class actions in most European jurisdictions at this point in time, or in the near future even. But as a company responsible for the breach, you do want to take a position on how you deal with compensation inquiries from affected individuals, right? It's not uncommon these days for compensation requests also to be accompanied by a threat, even to file a complaint with the supervisory authority, right? You may think that you have told a fair story to the supervisory authority, but will the position of that authority change once they start receiving complaints from affected individuals? So again, you need to take a clear position on how you will handle those. In other words, you need to have a plan, really. Now, on the other hand, when you notify a personal data breach to the supervisory authority, there's increasingly a risk that that regulator may decide to audit you, right? I think we're at the stage now where supervisory authorities are comfortable enough to start those investigations compared to a couple of years ago when the GDPR was all still fresh. And many companies seem to forget that, when you notify a breach, the regulators could ask questions about the breach, but also launch an investigation into your GDPR compliance overall. So again, you need to make sure you are ready for that. Don't take for granted just because you submitted a notification that there will be no follow-up from the supervisory authority. And in some cases, they will also want to look into your GDPR compliance beyond the personal data breach. I always give this example of what I think is a quite interesting case, was handled by the Belgian Data Protection Authority in 2020, in which a Belgian telecom provider had notified a breach, which involved sending emails to a wrong recipients. And the Belgian authority had some questions around the breach. It was initially a little bit annoyed because they felt like the company was not very cooperative. And they also had the impression that the company did not sufficiently assess the risk of harm associated with the breach. So they decided to dig a bit deeper into the company's GDPR compliance and found that the company's data protection officer was actually wearing 3 different hats, which is not allowed under GDPR. It was an accumulation of different positions and different roles. And they actually decided to fine the company for basically this conflict of interest that they had created, a fine of 50,000 euros, which obviously was no direct link with the personal breach as such. But I think it shows you how a breach can lead to a completely different result once you're dealing with the supervisory authority.
Yes, I agree completely, Wim. Thank you. And I know we've heard a lot from the lawyers, so let me just turn to from a technical perspective, Andrew, again, back to you, again, following up on the regulators' actions. So I'm sure we have all experienced how each regulator has its own preferences on responses and appetite for investigations. But from a technical perspective, Andrew, could you please walk us through what you have seen some regulators maybe after, if there is an investigation? Are there any effective strategies which you're advising clients should implement when there is a supply chain attack?
Yeah, Jenny. Well, for a technologist, you're going to now hear me say it's not all about the technology. It's as much about the process, the procedures, and the training that you put in place. When we're talking with clients, we're talking about what we call the 5 pillars of cyber wisdom. You need to lead from the top. There isn't a silver bullet. The board needs to set the tone and apply appropriate governance for data, set the risk appetite and tolerance for the organization, and have that flowed down. And it's flowed down in the policies, the procedures, and the controls that are put in place. And that's the 2nd pillar. So making sure that you develop policies, process, procedures that will deliver the mitigation of risk that the board is looking for. Some risks can be accepted. Others can be transferred through things like insurance, which has already been mentioned, and to the crux of the matter, made an obligation in the supply chain. So you decide that the risk is better handled by your supplier, and you work with your supply chain partners to make sure that they are then addressing the risk. The 3rd pillar, I would say, is infrastructure and standards, making sure that you've adopted appropriate standards where they will benefit the business, help you in the delivery of risk mitigation, the control of data, and addressing the threats that are there. There are a multitude of standards, European, international, US standards, all of which can contribute great thoughts and structure to your management of risk internally and in the supply chain. And Wim earlier in his session on particularly contracts looked at a number of those and how you can address them in contracts. But make sure that infrastructure is in place and tested. The 4th pillar, I would say, is people and training. Make sure your staff and your suppliers understand what they do in terms of managing security, in terms of alerting, in terms of responding to a breach. Christian has talked with great knowledge on the steps that need to be taken and some of the high-level do's and don'ts. Training your people, your supply chain, and indeed those experts that you're going to bring in on how to respond and how to work together is crucial in handling any breach scenario. If you're doing a tabletop exercise just to test your incident response plan, involve your external counsel, involve your forensic provider, involve your crisis communications company. You've all got to work together seamlessly, and if you've rehearsed together, you're far more likely to get on the front foot quickly in handling the breach. And finally, relationships, and I don't just mean in this instance those with external counsel and forensic providers. I mean, how do you have an ongoing relationship through your DPO or other channels with your supervisory authority? Do you know who to engage with in law enforcement in your local jurisdictions so that you can get assistance from the police or other law enforcement agency as you require it? Build those relationships now, know who to turn to, because in a crisis, the last thing you want to be doing is running around trying to find who you should be communicating with. Build that pillar of a strong base of relationships early. All of those together will form part of an overall strategy. But it's, if you start with those 5 key pillars, you will have at least the basis of an effective cyber protection regime that will help you respond to a cyber breach, whether it's in your organization or whether it's in your supply chain.
Great. Thank you, Andrea. I hope people were noting down the 5 pillars, really interesting and very useful. And then in that context, Kristen, you touched upon data management, and actually all the panelists, they say how important it is to know your data. Can you please elaborate on this a little bit further? In practice, do clients achieve that, strive to achieve that, and how do they achieve it? Does it have broader ramification than just the cyber attack on a supply chain?
Absolutely. I'm happy to do so, Jenny. And just let me kind of briefly also respond and highlight the importance of what Andrew just mentioned in terms of relationship management. There are so many different stakeholders also on the public authority side, right? The police has different interests than the company may have, right? And if you have established good relationships with the supervisory authority, if you're a large company, potentially even with the local police on the state level, you can use these relationships to kind of align the approach, which is oftentimes really critical for a good approach. So I think that was really a very important point Andrew just made. But know your data is really extremely important. And as I mentioned, many companies don't know the data for obvious reasons. It's a pain, right? I mean, we are getting all information from all different resources into different systems, and kind of looking down and going through the systems, understanding where the data is painful, it's costly. But maybe, I will kind of also point out how important it is from a different angle, so that potentially those who may think that they do not get the right budget for kind of doing this necessary exercise can think of a little bit more creatively on how to get the budget. So why is it really important to know your data? For various reasons. If you do not know your data, you simply cannot comply with your legal obligations. You will lose too much time. You may notify the wrong recipients, right? Think about when you're a data processor and you reach out directly to the supervisory authority because you have not understood that you shouldn't be doing so. In fact, you should reach out to your customers and the controllers, right? And so you may also breach your contracts. Also, if you kind of go and reach out to supervisory authorities and say, look, there was an incident, but actually we don't know what the incident is about, and maybe in 6 months we will get back to you. If you think that 6 months is a long time, no, it's not. It can easily take more time in order to really understand where massive amounts of data have been and how they have been compromised, and to do in particular also the risk of harm analysis under the various breach notification laws. So effectively, this doesn't come across very well, right? Because then the supervisory authority very well understands that you actually did not know at all which data you were using, for which purposes, and where the data was actually there. You can also not determine the lead appropriate supervisory authority. Oftentimes, if you do not know where the data came and where the data in particular was processed, is it personal data or not, you cannot control the communication because you may need to be overly conservative, right? So you cannot, for example, reach out if there was already a leak, and oftentimes there's a leak, right? And then you need to kind of respond to this. If you know exactly what data was compromised, you may be able, maybe in the kind of lucky situation to say, actually, yeah, we had a hack, but what the heck, it doesn't matter, because the data is not so sensitive, because we have taken all these precautions, because the data was fully encrypted, whatever, right? But if you don't know, you need to be overly conservative. You need to say, we don't want to comment on it. It's an ongoing investigation. It doesn't come across very well. You will most often risk your business relationships because it doesn't show the required level of sophistication if you don't know which data is actually compromised and which legal obligations you're subject to. You may also lose significant money because you cannot take a risk-focused approach, right? If you know that, there's large amounts of data which are really fairly harmless, you don't need to waste a lot of time and efforts on really understanding what exactly this data is about. In order to make notifications, you can immediately kind of discard that and focus really on the more important data. And secondly, apart from cyber right now, for privacy compliance, right? I mean, you need to know the data for privacy compliance. You cannot be compliant and you will not have a defensible position should a supervisory authority understand that you do not know which person data you have. Think also about international data transfers, something that is really on the top of the mind of pretty much everyone doing international business. We are all certainly very busy as your lawyer is working on it. But when we ask our clients and say, can you please let us know which specific data is transferred where, oftentimes clients don't know. When we work with them to kind of prepare intra-group agreements to, for example, to really clarify and safeguard the data, the necessary foundation for all this is to really know the data. And clients still often say, look, we don't want to really do the data mapping. Can we kind of brush it off, be a little bit more generic? It really doesn't work. But also when you think about data can also often be really know-how, right? I mean, it can be sometimes really the most valuable assets that your company may have. So if you know which data you're having, you may need to inform specific stakeholders within and outside your company, your contractual partner, the CEO, other regulatory authorities, business partners that send you data, in particular in such a chain, right? And last but not least, and that may be the most creative way, think about data monetization. If you know what data you have, you can also think about growing in revenue, right? So instead of just thinking about spending money, you can also think about making money potentially, right? But you first need to know. And that is something that I would really encourage every company to think about. And maybe that kind of helps you also getting the right budgets for it.
Great. Thank you, Kristen. Very helpful and very timely. I see we have a few minutes left and we do have some audience questions that have been coming through, and I think it would be good to address them. I thought we might get away without mentioning Schrems too, but clearly it's a cyber panel, so we couldn't quite manage that. How about, so we have a question, and thank you from our participants. So is there a difference, going back to what people can proactively do, is there a difference in due diligence between evaluating a supplier of software that will run in your enterprise as opposed to where an external provider of service would be doing that? And I would add to that a question that has been on the back of my mind, because supply chains are so hard to detect. We are more asked now to advise about intrusion detection and how best to approach that. Some clients have branched into AI, some have used various other models. So would anyone on the panel like to address that? Any of these?
I'll have a stab to start, and let the others come in and correct me afterwards. But there are some huge differences between acquiring software to do it in-house and actually outsourcing a functionality. If you're buying specific software for a particular task, and often we're talking about specialist tasks rather than just do I go with Microsoft or Lotus Notes for handling my email. But there are certain checks you can do in terms of application testing from a penetration testing point of view to understand the functionality, how the data is processed, how it is stored, does it get copied out to a cloud or to the software manufacturer's systems for part of the processing, and then come back, because you need to understand that processing and where that data is being routed, and under whose control it is as part of your protection mechanisms. Where you're outsourcing to an organization, you can stipulate those far more easily in a contract where you need to. You can set standards, you can audit, as Wim was previously mentioned. But if you're just buying a commercial product with a EULA license, for instance, your opportunity to dictate those terms and make sure that it complies with your own risk strategy, risk approach, and the way you do business is a lot harder. But it all comes down to an understanding of the risk that functionality of processing in-house or outsourcing poses to your organization, and the criticality of the data that's being processed. You need to understand those before you can take the decision. But one gives you far more freedom than the other, but may well be excessive. But you can work that out based on the risk that you perceive to the organization.
Yeah, Jenny, and I would probably add to that, you also want to understand the exact role of the supplier, right? I mean, is it really a processor, right? Or, I mean, it seems obvious in a software as a service type of arrangement, but there may be other situations where the supplier is really not in a processor role, and then all the liability lies with the controller, the user of the software itself.
Yes, very valid points. Thank you. And I see another question, which is almost as a solution. So, do we see any movement to blockchain to strengthen supply chain management? I'm sure you have views. I think from my perspective, I can certainly say my clients have started exploring that, and we're regularly advising on cybersecurity is one of the strengths of blockchains. There are pluses and minuses, but I don't know if anyone else has a view on this.
Again, I'm happy to take a start, but the audit functionality of blockchain and crypto blockchain is one of its great strengths. Too often when people are talking about blockchain, they're talking about Bitcoin and cryptocurrencies, but there is so much more functionality in there that can be used to put some real strength into supply chain management, into communications management, and providing that audit trail and thus accountability for actions that have been taken with data. So I think there are real benefits there, but I'm not seeing it being taken up in the way that I fully expected it to when we first started looking at blockchaining 20, 30 years ago. Now I'm just showing my age, but there's functionality there that could be used, but it just unfortunately isn't at the moment.
Yeah, I would agree. I see we have only 2 minutes, so I would like to wrap it up with some final remarks, just as an elevator pitch. If you could just share some must-know tips for our audience if they are facing an investigation or a cyber attack on the supply chain. Bruce has come, so I think we really have a minute or so. So let me start. Christian, could I start with you, please?
Sure, and I make it really, really short, and I'm sure we all have this information. I just want to really encourage everyone to reach out to all of us, because we all have prepared documentation on really helping clients getting prepared, and be prepared is really the key message that I really would like everyone to come across. So all the do's and don'ts and the precautions you can hear and more from us if you kind of reach out to us. Thanks.
Great, thank you. Wim, how about you?
Yeah, Jenny, I just wanted to re-emphasize a point that was made earlier about not ignoring the data transfer aspects, particularly in light of the Schrems 2 case from last year. And if you're dealing with a processor outside of Europe, just bear in mind that as a controller, you're facing potential liability, not just for the circumstances around the breach, but also possibly for not complying with data transfer restrictions in the GDPR. And that can be a challenge.
Great. Andrew, final words from you?
I'd re-emphasize what Christian said. You can't beat good planning and testing of those plans to understand where your weaknesses and vulnerabilities are and address them before it's too late. Build those relationships, as I discussed in the 5 pillars. Know who you'll be working with, and just make sure those communications are open and ready to go in the event that a breach or suspicion of a breach comes around. Great,
thank you. And a final thought from me then, be ready, and when you do face an attack, come and seek help. So Bruce, back over to you.
Thank you, Jenny. Very well done moderating job. And Christian, Andrew, Wim, thank you so much for joining us today. That was terrific. Great topic, and really important and timely topic. So next panel is on national security. It's a spotlight Q&A with a senior representative from the U.S. Department of Justice, John Carlin. So we'll be back at 3:35 for the next panel. Thank you.